Okay, everybody. Thank you very much for everybody joining us today. I'd like to welcome you to the 2025 Legacy Spring Cleaning Seminar, or webinar, I should say. My name is Mark Krause. I'm an associate estate planning attorney with Copenbarger Copenbarger. As Lloyd Face suggests, our founder, we are happy to see you. Our mission is to provide you with high-quality legal services and education to our entire community of friends and neighbors while carrying out our purpose with integrity, honesty, honor, and trust. Today, I will be joined later by Charles Sosa, who is the CEO, we call him Chaz, who is the CEO of Lifestyle Financial Services. And we will collectively talk to you about keeping your plan up to date and yourself protected. So we're going to run through a few topics today. We're going to ask, whether or not you've established any sort of protections for your estate yet, whether or not you've kept your plan updated through the many changes that you go through during life, and whether or not you've kept your plan updated as the laws change. At Copenbarger, as you can see up there, we have a number of attorneys. It's not just a solo act with Lloyd. Lloyd has built a really strong team of attorneys, including myself and some other attorneys that are a little bit of the younger generation. The firm's been around, I think Lloyd started about 45 years ago, and he's building a team to make sure that hopefully it'll keep going another 45 years. And obviously, we can't do anything without our wonderful staff. We have a very large, diverse staff of just really strong people that, thank goodness, are around me to help make me look good every day. We have a variety of locations throughout Northern and Southern California so that we can accommodate all sorts of needs based on location and where, it would be convenient to meet with you or do signings with you. So the first thing I'm going to talk about are the foundations of estate planning, just the basic essentials. First, what is an advanced healthcare directive? Hopefully you all have one. If you don't, the two main things advanced healthcare directive does is give somebody an exemption from HIPAA. Hopefully you all know what HIPAA is. HIPAA restricts doctors and medical staff's ability to share your healthcare information with anybody. So first, we need to give somebody an exemption from HIPAA. And the next thing, the main thing a healthcare directive does is give somebody the ability to make healthcare decisions for you, which is particularly important when you can't make those decisions yourself. We recommend, obviously a trust is something that possibly not everyone needs. It has something to do with the size of your estate and your assets, but everybody over the age of 18 needs an advanced healthcare directive because anyone could find themselves in a position where they're not able to make their own healthcare decisions. And without a healthcare directive, you really don't have anybody in place to find out your healthcare information and make those decisions for you. There's a few things if you move forward doing one with us. There's a variety of decisions actually that we're going to make within the document. One of them is we will decide when it becomes effective. It also will control certain things about end-of-life decisions. And we can go through all that if we move forward and have a discussion about that. It's important to note that Kaiser recently was creating some issues for clients because they had their own special little unique language as to when the healthcare directive becomes effective. Rather than trying to fight Kaiser, our normal policy whenever our clients run into a challenge like that is to not fight against the waves, but to just integrate it into our healthcare form so that our clients don't have any problems. Obviously, things can be resolved in court, but that takes time, money, and energy that, frankly, is generally not best used in that direction. So we've incorporated that language into our healthcare directives. If you do use Kaiser, you might want to talk to us about we can do potentially redo your healthcare directive, or if all that needs to be done is add that language, we can potentially just add a little addendum to add that language to make sure you don't run into any issues when you're using it with Kaiser. Durable power of attorney. Sometimes a healthcare directive, this can be confusing because a healthcare directive can be called a durable power of attorney for healthcare. But when I'm using this terminology of a durable power of attorney, I'm referring to the ability for somebody to make financial decisions on your behalf, not healthcare decisions. So this appoints an attorney in fact to be able to make certain kinds of financial decisions and help manage your financial assets for you. We again recommend this is not one of those things that there's a threshold of assets or net worth. Everyone who's over the age of 18, I would recommend, needs a durable power of attorney for financial. If for no other reason, imagine the same sort of scenario where you need a healthcare directive. Let's say you're in the hospital and you're incapacitated. Who's going to pay your bills for you? Is anyone going to be able to access your bank accounts? If that is, if there is nobody already in place that's able to do that, you'll need a durable power of attorney for financial. Conservatorship. This is kind of a dirty word in our practice. You may have heard about this. It kind of came into popular parlance through the Britney Spears saga. She was arguably a little mentally unstable, and so her father got a conservatorship over her to help manage her finances. And essentially what a conservatorship is somebody has to go to court and ask for the authority to gain to be appointed by the court to be a conservator, which allows people certain powers to manage either the personal and health cares related affairs of a person and or their financial life. We call this the difference between a conservator of the person versus a conservator of the estate. Oftentimes, when you petition the court for a conservatorship, you ask for both. This is very expensive, very time consuming, even to just initially get appointed as a conservator, because you have to prepare a petition, usually costs with an attorney a few thousand to just prepare and file the petition. Then you actually have to hope nobody fights you on it. So it can be a very time consuming, very expensive option, and the court will have ongoing power to oversee and review all the actions of a conservator. And there often is a ongoing requirement to file accountings that the court will review and approve. A will. Hopefully, again, everybody has a will. This is, again, one of those things where I would say everybody over the age of 18 should have a will. Certainly, sometimes we do standalone wills, which are different from the pour-over wills that you'll have if we've drafted a trust for you. Everybody needs a will. A will is sufficient, arguably, if your entire estate is worth less than the current threshold of $184,500. That's the threshold where your estate will have to go through the full probate process, which, like the conservatorship process, is extremely time-consuming, expensive, and inconvenient, and difficult to navigate, I might add. If your estate is below that current threshold, which is likely to go up this year, but current threshold of $184,500, a standalone will might be sufficient to control where your assets go. Obviously, the purpose of a will is to appoint somebody that has authority to carry out your wishes with regards to your property after you die, and to actually lay out those wishes clearly in a document so that they have a clear rules that this person's called an executor, that your executor has to follow. The other thing that's really important about a will that people often miss or don't know is that if you have minor children, you need a will to nominate a guardian. Nominating a guardian, if both you and your spouse pass away, or both parents, I should say, of the children, whether or not you're married, pass away, then the court will ultimately need to appoint somebody to be guardian of those children. And if you don't have a document ahead of time, which in this case would be a will that provides for a nomination of guardian, then you really don't get a say in who takes care of your kids if that happens. So a will is very important if you have minor children, because it allows you to have a say in who raises your kids if both parents pass away. Probate. This is an even dirtier word than conservatorship. This is probably the dirtiest word in my profession. We really, really are motivated to help you avoid probate if possible. So if you're asking what is probate, it's a legal process that follows state-specific rules about what happens to your stuff when you die and how the whole process works to transfer things after you die. It also deals with paying off any legal obligation you might have. If you owe anybody any money, that's going to get dealt with through the probate process. Hopefully, if anybody owes you any money, that'll be dealt with through the probate process on the brighter side of things. If those things aren't dealt with through the probate process, there are statutes of limitations that will run, and then those things will essentially no longer, those liens or obligations will no longer be in place, but they have to be dealt with through the probate process. It'll cost somewhere around 5% to 7% of the gross value of your estate, which can be quite expensive. And that's typically best case scenario. The amount of money an attorney can charge you it's not hourly, it's predefined by the probate code as a certain percentage overall of the estate. But that can be added on to with things that we call XO fees. That stands for extraordinary fees. So anything at all out of the ordinary throughout that probate process, the attorney can add on an hour, typically on an hourly billing basis, additional fees beyond the statutorily allowed fee just for the probate in general. This can be an extremely lengthy process. Best case scenario, you're probably going to see at least 1.5 years to get out of a probate if everything goes very smoothly. If things don't go smoothly and you have to do a lot of continuances, probates can easily last 2 years in Southern California or Northern California. And I know that many firms, because I've been a part of more firms than just Copenbarger, I've been a part of firms that have a backlog of certain problematic probate cases that can be as old as 5 years or more. So this is definitely not a quick, easy, or cheap process to go through. Living trust. Obviously, as many of you hopefully know, one of the biggest features of a living trust is that it avoids probate. It's a way to not have to go through that awful probate process. It also protects your privacy, something you may not know about probate, in addition to the inconvenience, length of time, and the cost of it, is that all your documents are a matter of public record, which means somebody that regularly accesses the court websites like me, I can basically order any of the documents that are filed just about in your probate case. So if you have any feelings about keeping any of your financial information confidential, or what happens to your stuff, or who your relatives are, anything like that, if you're concerned about protecting that kind of privacy, you do not want to go through the probate process, because all of that stuff will be a matter of public record that somebody like me can easily look up whenever I want to. Doing a living trust allows for various kinds of tax planning to help do the best job that attorneys can do to avoid paying higher taxes than you might otherwise have to. It ensures, obviously, that your wishes are carried out like a will. But the thing about a trust is it only protects what it owns. A trust sets all the rules for any property held within that trust, and the kinds of rules regarding the management of that property while you're alive and what happens to it after you pass away. But it only protects, those rules only apply to assets that are held within that trust. If the assets are outside the trust, then the rules can't apply. It also it can help avoid court supervised guardianships and conservatorships. Like I said, conservatorship is one of those dirty words that we want to avoid. If you do become incapacitated and you have a trust, your trust will allow a successor trustee to help manage that entire trust estate and use those assets to take care of you on your behalf. So that, hopefully that, along with an advanced healthcare directive and along with a durable power of attorney financial, provide a complete plan that avoids the need entirely for a conservatorship and keeps the court out of your business. A pour-over will. So I touched on this earlier a little bit when I was discussing wills in general. A pour-over will is a special kind of will that works with the trust. The basic idea is that it's a contingency that we hope to never use if you have a trust, but the idea is if something mistakenly is left out of that trust when you pass away, the pour-over will collects the asset and then pours it back over into the trust. That's why we call it a pour-over will. Your executor will be the same people if you have a trust. Your executor will be the same people as your successor trustees. And the distribution provisions of the pour-over will simply say everything goes into the trust. Now, this is not ideal. It's sort of a last contingency plan if something goes wrong, because a pour-over will does have to be probated. It does have to go through probate. Something I should be very clear on: a will does not avoid probate. Simply having a standalone will not keep you out of probate. It will allow you to control ultimately what happens to your things and hopefully who your executor is, but the will has to be administered through the probate process. Same with the pour-over will. Letters of instruction. This is a very general term that can refer to all sorts of things. One of the things that's a feature of our trusts is that you can use a letter of instruction to specifically, sometimes we just call it a written memorandum, to provide for specific gifts of tangible personal property. That means your physical personal property, furniture, jewelry. If you have sports memorabilia collections, that sort of a thing, you can actually, based on the provisions, at least of our trust, the trust we draft, do a written memorandum to provide for where certain of those kinds of items will go to. But letters of instruction can also be in your estate plan to provide burial instructions, to give certain kinds of notifications to be, to the people that are going to be taking care of your estate after you about maybe where certain assets are. If you have things in a safety deposit box, if you have certain accounts that might be hard to find, if you have, a financial planner that you want them to contact, there's all sorts of things you can put in a letter of instructions that'll help those who are taking care of your estate after you, just essentially know what to do and be able to hit the ground running. Life planning for every stage. So obviously, it's important, you might have, maybe a lot of people maybe do your estate plan after you have your first child because you realize that important, or maybe, even more often right after you buy your first house. But if you leave that estate plan exactly the way it is throughout your life, that can create some issues because obviously as life changes, your estate plan arguably needs to change as well. For instance, if you're going to move, it's important to know that if you've done a trust with us or anybody else, it's California trust. Your California trust is valid in all 50 states. The full faith and credit provision of the Constitution provides for that. But you need to make sure that your trust is funded. Before you're going to make any moves, you need to make sure that your trustees and beneficiaries, the trustees are the people that have management and control over the trust assets, and the beneficiaries are the people that the assets will be going to help them out. You need to make sure those are current because obviously sometimes your backup trustees might no longer be with us. Sometimes your relationship with your beneficiaries can change. Maybe you had a friend or even, God forbid, a child that your relationship has radically changed with. And sometimes you might have a spouse that you're no longer with. You need to make sure that also that all your financial assets and all the deeds to your home are kept up to date and that everything that's supposed to be in the trust is in the trust. As I mentioned, marriage and divorce are big issues that relate to life planning. There's something referenced up here called an AB trust. Some of you may have it, some of you may not, and some of you may not know what it is. Essentially, an AB trust provides that on the death of the first spouse, the trust bifurcates into two separate subtrusts, one for the deceased spouse and one for the surviving spouse. And the deceased spouse trust essentially becomes irrevocable, meaning it can't be changed. Specifically, what can't be changed are the distribution provisions of the trust. So that becomes very important because the surviving spouse may remarry. If the surviving spouse remarries, they potentially are going to have an interest in providing for that new spouse. I don't mean to be sexist, but in our experience, or certainly in my experience, men tend to be much more susceptible to that kind of a thing. They are much more geared towards providing for that new spouse. Women are a little better, tend to be a little better at protecting their kids and making sure that they're not adding a new spouse if they do get married into your trust. But in either case, stereotype or not, it's something that can provide protection so that if you pass away first, it limits the ability of the surviving spouse to change where the stuff's going in your trust. At least will protect your half of the community property and any separate property. If you become divorced, obviously, that's time to update your trust. Please don't leave a marital trust in place if you have been divorced. That is going to create a lot of problems. We'll need to update your trust and sort of bifurcate and separate those things. But divorce also leads to blended families, which is another impetus and reason to create potentially an AB trust to make sure that your kids are protected. If you're in a mixed marriage, a blended family, and you pass away, it's not for sure that your spouse is going to, prioritize their kids over yours, but it's certainly a temptation, and it happens often enough that I would always recommend an AB trust in that sort of a situation. Creditors, predators, and divorce. Something that people don't necessarily discuss that often, but we do all the time. Generation skipping provisions of a trust. Generation skipping provisions were originally used more for advanced high wealth situations to offset the tax consequences, the estate tax consequences to the next generation, to sort of skip over the generation of your children. But we often use them for their protective aspect in our firm. And essentially what they do is they allow you, instead of simply distributing trust assets outright to your kids or whoever your beneficiaries happen to be, it allows you to, and outright just means free of trust. That's the simple, no nonsense. You give them cash, you give them a check, you simply transfer assets directly into their name. Instead, setting up a generation skipping trust provision, which we also sometimes refer to as a lifetime protective trust, allows their distribution to be made to them in the form of a lifetime protective trust that'll essentially protect their inheritance throughout their life, so long as they keep assets in that trust, by providing a legal degree of separation. Essentially, they don't really own the assets. Their lifetime protective trust will be the actual owner of the assets. But if you name that beneficiary as the trustee of that lifetime protective trust, they'll have full management of control over those assets. They can use them any way they want, but it'll be protected from any legal action taken against them, whether it's an action by a creditor, any sort of lawsuit, like a personal injury lawsuit from a car accident, a bankruptcy. The bankruptcy trustee will not be able to go after anything held in that lifetime protective trust if they have to declare bankruptcy. And especially important, divorce. A divorcing spouse will not be able to have access or receive a share of anything held in those lifetime protective trusts if that's the way that you've set up for your beneficiaries to receive their inheritance. So this can be a very powerful and important protective device to ensure that your child's inheritance, or whoever your beneficiary might be, has their inheritance protected. And it can be really important, even if they make a great calamity out of their life, if they go through divorce, bankruptcy, if they get sued, all these things, lose all their other personal assets. By protecting their inheritance in this way, you can give them something to essentially fall back on that none of those forces will be able to take away from them. Protecting a beneficiary with an SNT. An SNT stands for Special Needs Trust. That becomes important if one of your beneficiaries collects certain kinds of government assistance, like SSI, Social Security Disability benefits. Special Needs Trust would allow you to leave assets that'll be set aside for their benefit, but that won't interfere with their ability to continue to collect government benefits. Essentially, what we do is if we create a special needs trust, or sometimes we call it a supplemental needs trust, it'll keep those assets separate instead of simply distributing to them, which will ruin, potentially cut off their ability to collect those public benefits. It'll keep it in a separate trust that whoever you appoint as trustee will be able to use to essentially help them out around the edges and supplement whatever the public benefits are not helping them with or not providing for them, without interfering with their ability to continue to collect those public benefits. If you have a child that has certain kinds of disabilities, this is a very important planning issue that we definitely need to talk about. And sometimes those special needs can emerge later in life. And if you have a previous version of your trust, or the current version of your trust doesn't have this included in it, and you have a child that maybe even as an adult now that special needs have emerged that now collects SSI, this is something that you're going to want to revisit and discuss with us. Email isn't enough. Please, please, please do not, if you're trying to amend your trust or any of the documents we've talked about, any of the estate planning documents, you can't just email us and say, like if any of you watched The Office, Michael Scott, when he declares bankruptcy by yelling, "I declare bankruptcy," that's not valid. You can't just declare that you're amending your trust or any of these documents. Emailing me or somebody else in the firm to notify us doesn't effectively amend or change any of these documents. It's really something that needs to go through a formal process in order to do it correctly. So if you want to make any amendments, please see us and discuss that with us so that we can help make sure that those amendments are valid, that they don't interfere with anything else you're trying to do with your estate plan, and that the amendment itself will actually do what you want it to do, because obviously if it was completely simple for everybody to do on your own, if this was a completely simple, do it yourself kind of process, then there wouldn't be so many firms that do this, frankly. Staying ahead of legal changes. Real quickly, I'll try to touch on a few important legal changes you may or may not be aware of. The parent-to-child exclusion. Previously, if you wanted to transfer a home to your child, the parent-to-child exclusion was something that would allow you, as long as it was a parent-to-child transfer of real property upon your death, it would prevent your home from being reassessed by the county for property tax purposes. So this can be very important if you've, purchased a house in 1972 in, say, Orange County, California, where I live. You may have bought a house that at the time was $30,000 in 1972, and it has a taxable basis based on that value. And if there were to be a step up in basis, it could prevent your child from being able to afford to live in the home after you, even if it were the case that you've entirely paid that house off. The property tax change alone, reassessing it in terms of its current value, because oftentimes that $30,000 house is now worth $1.3 million. So that can, cause major issues for the child you're trying to transfer it to. It used to be that any parent-to-child transfer on death qualified. Prop 19 drastically restricted that. That's the applicability of that exclusion, so that now it has to be that the parent lives in that property as their primary residence for at least 2 years, and the child has to be taking it as their primary residence. If this is something that's of concern to you, I would recommend again that you talk to us about this. There's some certain things we can do. We certainly can't totally get around this, but we can at least try to help facilitate a parent-to-child transfer that will qualify for the exclusion if that's something that you want to do as part of your plan. Changes to Medi-Cal. There's a lot of complicated numbers on this slide, but the simple thing to know is that as of last year, Medi-Cal, which is really important, especially if you or maybe your spouse ever needs to be in a full-time care facility due to things like Alzheimer's or dementia. Previously, the litmus test for qualifying for Medi-Cal was asset-based, and now it is income-based, which has radically reshuffled the deck on Medi-Cal. If Medi-Cal is something that you want to potentially plan for, if it's something that you might need now, I recommend that you come talk to us. We've developed a new Medi-Cal trust that works with the new rules to try to help reclassify certain kinds of income so that it won't count against you, so that you can qualify for the maximum amount of government benefits through Medi-Cal. But this is a newly emerging issue that we've done a lot of work to be on the cutting edge of. So if that's something that you need to think about, please come talk to us about it. The Secure Act. The Secure Act affects inherited deferred compensation plans. So deferred compensation accounts. So if you have IRAs, 401ks, and they're potentially going to, if you've got the trust listed as a beneficiary, perhaps as a backup beneficiary, your spouse, if there's any chance that these kinds of accounts are going to end up funneling through your trust, which I will say, if you have generation skipping provisions, they absolutely should be funneled through your trust. The government has changed the certain rules about what needs to happen with those plans after your death. We have updated language that we put in our trust that informs the trustee of relevant dates, periods of time that they need to observe based on the Secure Act changes. So if that's something, that's a potential issue for you, again, I'd recommend that you talk to us about that. This just really quick, a fun thing for people to know. People don't always know what the current gift tax maximum is per year. Right now, it's, as last year was $18,000. Now it's $19,000 a year. You can gift tax-free to anybody that you want to gift to. And if you have a spouse, that spouse can actually give their own $19,000. So if you want to give each one of your kids from both spouses $19,000 a year, you can do that fully tax-free. Neither one of you has to report it. And I should also point out that the lifetime gift and estate tax is currently $13.99 million, which means that 40% estate tax or gift tax won't kick in unless you're transferring upon your death or during your life, and then upon your death more than $13.99 million, although that is potentially set to sunset after this year. So we're hoping that the current administration is able to extend that, but that's something that you should definitely be aware of. I will now turn things over to Chaz with Lifestyle Financial. And I just also want to let you know, I may have had questions coming in through the chat, but I and Chaz will be able to address your questions at the end. So if you do have any questions, I apologize if I haven't hit them yet, but we can go through, at the end of the presentation and answer a few questions if there's still questions remaining. So now I'll go ahead and turn things over to Chaz. I thank you very much for your attention.
Thanks, Mark. Good morning, everyone, and thank you for being here today. My name is Charles Sosa, and I'm representing Lifestyle Financial in proud partnership with Copenbarger Copenbarger. Today isn't just about spring cleaning your home. It's about organizing and simplifying the parts of your life that matter the most. Your finances, your plans, and your legacy. At Lifestyle Financial, we're more than advisors. We're a family helping families. We work with real people, parents, business owners, retirees, who want to protect what they've built and pass it on with intention. This presentation, we're going to walk through how to protect what you've earned, how to plan with clarity, and how to ensure your legacy continues for generations. Whether you've planned a lot or are just starting out, our goal is to give you insight, peace of mind, and actionable next steps. Our philosophy is simple. We're a family helping families. That's more than just a tagline. It's how we operate. Behind every financial plan is something deeply personal. It could be a loved one's care, a child's future, a dream that took years to build. We build custom strategies that reflect your values and your story. Our relationships are lifelong. We walk with you like family should. Who we are and services we offer. I work alongside Zachary Raymond and Amanda Best, a team that brings skill, heart, and most of all, integrity to every client relationship. Our clients know us personally. They call us, text us, and email us because we're present through life's ups and downs. Services we offer. Investment management, portfolios that are tailored to your risk tolerance and goals. Comprehensive financial planning, retirement, tax, insurance. These are all vital things that factor into the financial plan, as well as ensuring that you have estate planning in place. Personalized advice, rooted in your goals and life stage. And we do not believe in cookie cutter plans, only customized and evolving strategies. Preserving your legacy and securing tomorrow. Imagine 20 years from now, your family sits around the table feeling supported and clear because of what you put in place today. That's the heart of legacy planning. It's not just about legal documents. It's about preserving your values, reducing conflict, and ensuring peace of mind. We help you create a plan that aligns your values and protects your family long after you're gone. Why financial and estate planning matters. Ask yourself, how prepared are you to protect what you've built? Over 60% of Americans have no estate plan. Without ones, families face delays, court battles, costly tax issues. A strong plan, integrated with financial planning, minimizes taxes, avoids probates, and honors your wishes. Planning must be customized to your needs, your family, and your assets. Securing a sustainable retirement and legacy. Your investment should support you in retirement and continue to support those you care about. Our mosaic approach looks at the whole picture, all of the pieces. retirement planning, ensuring that you have consulted with an attorney and have an estate plan in place, looking at your taxable investments, Social Security, pensions, and so much more. We ensure that your money works for you now and for the people and causes that you love well into the future. Right now, we're in an era of uncertainty. I'm sure everyone could agree that the markets have been a little bit volatile. With rising interest rates, changing tax laws, there's a lot of things that are happening. But with a thoughtful plan, uncertainty becomes opportunity. A complete plan involves financial projections, tax strategies, estate documents, and insurance coordination. It's not just about surviving, but it's about thriving now and well into the future. From health to estate considerations. Wealth isn't just about numbers. It's about your health, relationships, and legacy. We offer a holistic approach that includes healthcare and long-term care planning, trust and estate documentation. In other words, ensuring your beneficiaries are up to date and also ensuring that trust accounts are titled properly. I can't tell you how many times we've met with people where they have accounts that are outside the trust that should have been updated and brought into the trust. Simple things can have large repercussions and ripple effects down the road. And ensuring that with retirement accounts, beneficiaries are updated periodically. Unfortunately, we go through life changes. I met with an individual and he still had his ex-wife as the primary beneficiary, and his current wife would not have been too happy if something would have happened to him. These are all things that need to be reviewed from time to time. Asset protection, and also charitable planning and tax efficiency. Studies have shown that families with a coordinated plan transfer wealth more efficiently and with significantly less stress. And let's face it, there's plenty of things to worry about. Let's eliminate one of them from the picture. How we can help you. Your estate represents a lifetime of work, but its full value is realized only when it benefits those you love. We help you design a 40-year legacy plan, not just for a short-term fix, but for now and well into the future. This includes proactive adjustments over time, strategic gifting and help with structuring trusts in coordination with a law firm, and constantly monitoring for tax and life changes. We keep our eyes on the horizon so that way you can focus on the people and values that matter most. Your financial legacy. Take a moment to reflect. What do you want your legacy to look like? For some, it might be a debt-free start for your children, a gift to your alma mater or church, the confidence that your family will be well cared for. Legacy planning is an incredibly personal process. Our job is to listen, understand, and then help you build your financial, legal, and investment tools to help you carry out that vision. If this conversation resonated with you, we'd love to connect. We offer complimentary consultations because planning should be accessible no matter where you're starting from. Whether you have a large estate or just beginning to plan, seriously, we're here to help. So let's start a conversation. I know I covered a lot of wide-ranging topics, but really, with our custom approach, a lot of these conversations are best when we have an opportunity to really learn more in depth on your situation, and then we can gear that meeting towards answering your specific questions. So, and with that, I'm going to turn the presentation back over to Mark.
Thank you. Hopefully, there we go. Sorry about that. Hopefully, there we go. I'm back. Uh, thank you, Chaz. So conclusion, how we can help. Like Chaz said, with regards to lifestyle, there's a lot that I threw at you as well. You know, it was a lot of dense subject matter, and these things are better in person in one-on-one scenario. That's where we can really get to know who you are, get to know who your beneficiaries are, you know, from you, know what your goals are, know what those family dynamics are, and we can really, you know, help guide you through an estate plan that's unique to you and actually tailored to your needs. We can answer all sorts of questions and, you know, in keeping with our founder, Lloyd, you know, we do see this, you know, I personally do see it as a ministry as well. And, you know, we can help, you know, do everything we can to just, you know, be a blessing to your life and help you accomplish what you want to accomplish with your estate planning. Um, you know, obviously, establishing a plan, it's very important to determine who you want to be your successor trustees and your backups for your various estate planning documents. Um, and, you know, to make sure that, you know, what you're leaving to your beneficiaries is really going to help them in the best way. And we just, if you haven't come and if you've seen us before, you haven't seen us for a while, or if you did your estate planning somewhere else and it's been some time, we would ask you and recommend that you come in and at least do a review with us. If I believe through this webinar, you know, we're able to set up a free appointment with us to go through your estate plan. I can, you know, go through it and discuss it with you and make sure that it's up to date, that it reflects any legal changes, and that it's geared to accomplish what you want to accomplish. Why should you work with Copenbarger? As I alluded to earlier, we've been open since 1979 when our founder, Lloyd Copenbarger, who is still with us, working a few days a week, and is personally a mentor to me. That's, you know, I'm getting to learn from the best, which is an awesome place to be in. We have 8 full-time attorneys, couple of counsel and CPA on staff. We have not only an estate planning department, we have a litigation department, we have an estate administration department that is very good at what they do. We also have a business and tax department that can help you with all sorts of things, including business planning, setting up corporate entities and LLCs, and just, you know, advise you through tax issues and help guide you through that. We have multiple attorneys on staff with advanced tax degrees, not just Lloyd, but definitely Lloyd, certified specialists in probate, estate planning, and trust law. Over 45 highly qualified support staff that, like I said earlier, make me look good every day. And we have 8 office locations and the ability, you know, if necessary, sometimes to travel to other locations. So we have a wide presence all over California. And of course, the ability to meet through Zoom, which really, you know, makes the world a much smaller place and allows for meetings, you know, with us no matter where you happen to be. I've met with clients as far away as Thailand through Zoom. We had to meet at a weird hour, but it's really amazing what technology allows us to do now. So at this point, we've got some of our information listed up there of specific importance. I want to highlight, in addition to our contact information, there is a digital evaluation form that we would really appreciate it if you would fill out. It's going to be available, should be available in the chat. But like I said, we have a phone number, our website, email. Please contact us any way that works for you. And I know Chaz probably wants to make sure you have his information as well. But I think at this time, also in addition to highlighting the digital evaluation, I think Chaz and I have the ability maybe to field a few questions at this point. I know there's probably been a couple questions through the chat. You ready to field some questions, Chaz?
That's correct. We've got the chat up and our my contact information is in there for Lifestyle Financial as well. But if you folks have any questions, we are standing by to answer those right now.
Yeah, I'll give it, a moment in case anybody is, trying to formulate their questions. If you have any, if you just put it right there in the chat and send it to us. Either myself or Chaz or both will do our best to answer those questions. But obviously, if you prefer, we can always answer those questions probably even better and in more detail if you schedule an appointment with us. But okay, let's see. What is included in the 184,000 limit on probate? So really, this just has to do with your estate in general. Any of those assets that you would need to pass through probate. So, if for some reason you had an interest in real property, uh, if you had an interest in real property that maybe was smaller than 184,000, which in California is not super likely, but it's possible. If you had bank accounts that sometimes you can set up bank accounts to be payable on death, or you can put a child jointly on the bank account. There's various drawbacks with those as planning options. But if you haven't done that, the only way to actually do that is to have those assets transferred through the probate process. So you can get away generally with assets that aren't titled, like, personal property, jewelry, and things like that, to potentially be able to pass them without going through probate. But any sort of financial assets, real property, things like that are going to count towards that 184,000. And it's actually 184,500. And Trish, I believe, is sending me a message and answer
We have
David.
we have two more questions in the question and A.
Okay.
So one of the questions is, do you have letters of instruction formats available?
I think we could potentially help with some of that with the sort of memorandum that I discussed that enables you to provide for specific gifts of personal property in your trust. There really isn't a format necessary, but we can, certainly guide you through that. It's just as simple as you can write, I want to leave my signed Michael Jordan jersey to, my son Derek or something like that. It's as simple as just writing them down. Our guidance is that you do it in your own handwriting and that you sign and date it. For other sorts of letters instructions, I don't know that we have a ton of formats available, but it's certainly something that we can give you specific advice tailored to your needs, and we can help guide you through the process. And if necessary, maybe even help you draft something for you for your specific situation.
We have another question.
Sure.
So if two parents each give a child $19,000, do these $19,000 gifts need to be coming from separate bank account under each parent's name? If the 38,000 comes from a joint account, does each parent need to file a gift tax return?
So the answer to that is they don't have to come from separate bank accounts. The idea is just that, the money, I'd probably say, just to be clear, if they're giving somebody, a check for 19,000, maybe just have one parent sign the one check and only one parent sign the other check and have it come from two checks. But there's no reason it has to be from separate bank accounts. And the idea with regards to gift tax returns is that anything $19,000, and below, you don't have to file a gift tax return. That sort of gift tax limit, if you've not exceeded it, the whole thing gets to essentially fly under the radar. You don't have to file a gift tax return. The government doesn't have to have any interest in it, and you don't have to report it to the IRS. It's only for gifts that go above that $19,000 threshold that you would need to file a gift tax return.
That's it. We do not have any other questions at this time.
Okay, great. Well, I really thank everybody for your time and attention today. And we really hope that we'll get to, meet. Chaz and I both hope separately that we'll get to meet some of you in person and be able to discuss some of these issues further. Please fill out that digital evaluation in the chat if that's all right with you, we thank you for your time and attention today. And let me see. So one more question. Are deferred comp accounts included in the 184,000? I can answer this question really quick. Deferred compensation accounts may or may not be included, hopefully, and typically they're not. Deferred compensation accounts have beneficiary designations, and those beneficiary designations are sufficient to avoid probate. It'll just go to whoever if you have a 401k and you've designated your wife, say, okay, then it'll go straight according to that beneficiary designation. But if everybody you've listed on the beneficiary designations is deceased, or there's nobody available, then it will potentially get tied up in probate and count towards that 184,000. So anyway, thank you very much, folks. I appreciate it. And it was great spending time with you. Thank you.
It was a pleasure. Thank you.